Our next witness, Mr. Jeremy DeBeer, please.
Good morning, honorable senators. My name is Jeremy DeBeer, and I'm a full professor at the University of Ottawa's Faculty of Law, but I'm here in my individual capacity today to testify based on my experience researching and writing about international trade, technology, and environmental issues in general, and about CETA specifically. I have to begin by saying that I'm a strong supporter of international trade, and in particular, a supporter of CETA. I believe that on the whole, it's good for Canada. And I hope that my support for CETA and my admiration for the people who got this done for Canada over a long negotiation process and in difficult circumstances at the last minute contextualizes and also sharpens my remarks that follow. I have no problems with Bill C-30. It does exactly what it is supposed to do. My concern is about Canada's strategy, or lack thereof, in respect of intellectual property, technology innovation, and international trade. Now, this committee's report last year touched on intellectual property, but the opportunity now exists to make the bold statements needed to ensure that we can offensively advance Canada's interests in future trade negotiations. And to start that process, we need to admit our past mistakes. Canada's failure to make innovation strategy a priority when these negotiations began around 2010 and 11 put us entirely on defense. And we were all placated by promises that the IP chapter was mostly or largely consistent with Canadian law. Now, this committee is considering 50-plus pages of changes to the Patent Act and the Trademarks Act, plus several more pages of consolidating or coordinating amendments, and a 7-page schedule of 172 geographic indications that Canadians can no longer use to trade freely. So it's my duty today to warn you that the complexity of, for example, the new scheme for certificates of supplemental protection makes it almost certain that there's going to be unintended consequences, and entirely certain that there will be many years of litigation over the interpretation and application of this scheme. So there are major changes to Canadian intellectual property. Now, litigation also includes, as I wrote about in a special issue of the Journal of Legal Issues of Economic Integration, based on our CETA research, constitutional litigation about whether some of these provisions impinge upon provincial jurisdiction. It also includes more investor-state disputes, like the one Canada just defended against Eli Lilly over the principles of the common law and the sovereignty of Canadian courts to invalidate useless patents. Now, that Canada won that case should be a wake-up call for us about the dangers of this system. Weak cases will be brought, costing money and chilling our creativity to use the few regulatory flexibilities that we've retained. And CETA's dispute resolution or dispute settlement procedures aren't good. They're just less bad than NAFTA and other agreements. Now, on the IP issues, Canada's negotiating team and the supporting officials from across government did very well not to give up much more. But they were handcuffed by the lack of a mandate to do things much differently. There was no offensive mandate on IP in CETA because there was no high-level strategy to know what to ask for. Now, IP experts, including myself in this country, are energized by the government's commitment in the 2017 budget to create an IP strategy within the year. And we're willing to help, and I hope that this committee can convey that message. But it requires a complete reorientation in the way that we see and assess these kinds of international agreements going forward. These are much less about tariff-free trade than they are about global economic power structures. And our evaluation processes need to recognize that. It also requires a firm commitment to make policy based on evidence and not rhetoric. And I'm pleased to see that departments, including ISED, are already commencing that process. I've just published a review of methods and conclusions to make evidence-based intellectual property policy in the Journal of World Intellectual Property. I'm pleased to share that with this committee so you can see what tools are available to start that process. Now, I also endorsed this committee's recommendation for greater transparency in trade negotiations that echoes previous conclusions from my research. But I'll end with this. Consultations alone are not a substitute for forward-looking strategy. That's because today's most dominant lobby groups are not in the industries that Canada needs to nurture. The entrepreneurial companies that are most harmed by our stale international IP strategy can't participate because they don't yet exist. And they never will unless we create an international IP strategy that adopts fresh ideas to give Canadians a clear advantage on the global economic stage. And I'd be pleased to elaborate on how to implement that strategy during questions. Thank you, Senators.
Thank you. And our